So you found the love of your life, and now you want to petition for your stepchildren. What are some of the issues that you should be aware of? Hi, my name is Soyuna Tag. I'm an attorney and one of the founders of Adam Law Group. We plan to release weekly videos about the law, starting with immigration, on this channel. And as the channel grows, we will hopefully expand to include videos about some of the other areas of the law that we work in. So what I'll cover in this video will be when a stepchild can count as a child for U.S. immigration purposes, then considerations for a U.S. citizen petitioner, and then we can discuss considerations for a lawful permanent resident petitioner, and then I'll end with a couple some resources and some warning, couple comments, and hopefully that'll give you a better idea of what to expect in this process. I also want to clarify that while I'm vastly talking about petitioning, this is actually a two-step process to help your stepchild become a permanent resident of the United States. So the first step is the filing and hopefully the approval of the I-130 petition. And when immigration approves a petition, they are saying, yes, we agree that you and your stepchild, there's a real parent-child relationship. And that's it. It actually doesn't give any immigration benefit to your child. However, this petition, the approval of it, is the basis for your separate application or your stepchild's application for permanent residency. And that application, if the child is inside the country, would be called the adjustment of status process. And if the child is abroad, then that would be what we call immigrant visa or consular processing. First off, when can a stepchild count as a child for U.S. immigration purposes? First of all, what is required is that the child meet the definition, according to U.S. law and U.S. immigration, of being a child. And that means the child must be under 21 years old. So, we use words a little differently in the law and especially in immigration law. And USCIS, for example, distinguishes between a child, which is under 21, versus a son or daughter, which would be a child who is older or 21 years old or older. So when we say child, we mean under 21 years of age. Now, typically speaking, we're talking about chronological age. However, sometimes that may not always be the case. For example, there's a law called the Child Status Protection Act, where sometimes the legal age that we end up with is younger than the actual chronological age of the child. So that's probably a topic for another video. But generally speaking, the child should be under 21 years old. Another requirement to meet the immigration definition of a child is that the child not be married. So even if your stepchild is 19 years old, which means definitely under 21, if that stepchild marries, there will no longer be a child for immigration purposes. They will turn into a son or daughter. So it's really important to keep that in mind if they're considering marriage or things like that, because it'll definitely impact what is possible with immigration. Secondly, the child must legally be a child of your spouse. So typically that would mean a biological or adopted child, a relationship that is legally recognized. But you have to make sure that if the biological parent, for example, relinquished or gave up their parental rights, or the child was adopted by somebody else, that child is no longer recognized as a legal child of your spouse, in which case the child would not be your stepchild. So, and there's also regulations about, gestational mothers versus genetic mothers and things like that. But again, keep in mind that for our purposes, we need the child to legally be the child of your spouse, and that would make this child your stepchild. Another consideration about the legal status and the relationship of that child is that I get asked this question sometimes: if the U.S. citizen or permanent resident petitioner must adopt the stepchild. And no, that is not required for this purpose. In fact, I would add a word of caution that the intersection of adoption and U.S. immigration is very complicated. You have to look at whether the country's a signatory of the Hague Convention, and it's a very involved process. So I think that's a process, if you're interested in, that you would definitely want representation and, to work with an attorney on that. But for our purposes, to petition a stepchild, there's no requirement that you adopt, a stepchild in order to do this. So third, in order for the stepchild to count as your child for immigration purposes, your marriage to your spouse had to have occurred prior to the child's 18th birthday. And that would be the chronological age. So if the marriage occurred after the child turned 18, even though, of course, that child is your stepchild, the child will not count as a child for U.S. immigration purposes, where you can infer certain types of immigration benefits. So it's really critical, especially if you're close, that the marriage is completed and finalized and legal prior to the child turning 18. Those are the three main things I would say that are required to make sure that your stepchild actually counts as your child for immigration purposes. So if you are a U.S. citizen petitioner, then the relationship between you and your spouse is that of what we call immediate relative. And also the relationship between you and this stepchild is also an immediate relative relationship. And yay, that's actually a great thing in many ways, because that means you are not subject to what we call preference categories, which involves priority dates on this thing called the visa bulletin, and there's a bunch of waiting time before even the processing time. So all of that is not a concern, and you're just dealing with the actual processing time once you put in the petition and the relevant applications. So that's all great, but one thing that's really important to understand is that when you're dealing with this immediate relative relationship, these are the benefits. But one really important thing is that immediate relatives have no derivative beneficiaries. So what does that mean? For example, let's say you're a U.S. citizen and you wanted to petition for your sister abroad. And your sister is married and has 3, young kids. Well, you would file one I-130 petition and pay one filing fee, which currently is $535, to USCIS. And under that one petition of your sister, the derivative beneficiaries, which means her husband and 3 kids, would all come under there. But when you're dealing with an immediate relative relationship, and I should probably define what that is. That's only 3 types of relationships, which means 1, U.S. citizen to the spouse. 2, a adult U.S. citizen, meaning 21 or older, who is petitioning for their parent. And 3, a minor child of a U.S. citizen. So those are like the 3 types of relationships that would qualify as an immediate relative relationship. So when you do those, there is no dependent or derivative beneficiaries. And that's why it's really important that when you're petitioning for stepchildren, you would do an immediate relative petition for your spouse, and you would do one for each stepchild. So if there are 3, you would file 3 additional I-130 petitions. And yes, that would mean you would pay the filing fee for your spouse and the 3 kids. So you would pay the filing fee 4 times. But there's no other way to do it. And it's really important that, that distinction is understood. So again, you need to file this direct petition to each child. And that's establishing the parent-child relationship. So once the petition is approved, then if the child is abroad, then the visa processing, what we call immigrant visa processing or consular processing, that would continue. And then ultimately ending in a consular interview, then the child would receive an immigrant visa if everything is approved, and then immigrate to the United States. If the child is inside the country, then for this immediate relative child, your stepchild, you would be able to file the I-130 petition and start the adjustment of status process, which means asking for that green card. You would file everything concurrently, so at the same time. In that sense, I think even though there are separate petitions And, and the adjustment of status or the visas, those are always individual. So there's no option of ever having like derivative beneficiaries or something. That's all per individual. So now let's think of this from a situation where the petitioner is not a U.S. citizen, but a green card holder, a lawful permanent resident of the United States. That means you are subject to the preference categories. And that means potentially there's waiting time, depending on what the monthly visa bulletin says, that you have to wait out before the government will process the immigrant visa or an adjustment of status to permanent resident for your stepchild. And I really want to point out here that, because it can be really confusing, that the I-130 petition can be filed at any time. So, in fact, generally speaking, quicker you file, the better, because the date that your I-130 petition is accepted by USCIS of the U.S. Department of Homeland Security is what we call your priority date, should that apply in your case. However, the application for permanent residency, whether that is the adjustment of status process or the immigrant visa process, that the filing date is determined by the government and the immigration regulations. And for our purposes, the category is F2A, which would be for spouses and children of lawful permanent residents. And again, children meaning under 21, unmarried, and all the stuff we just discussed. So here, you have to pay attention to this thing called the Visa Bulletin. And that's published by the Department of State every month. It comes out about, halfway through the month for the next month. And it'll give what's called a priority date. And that's the date you filed the I-130 petition and it was received by USCIS. That is called your priority date. And you have to check to make sure that your priority date is current. So, and right now, if you look at the current visa bulletin, or for that matter, we can look at the February 2022 visa bulletin. If you look at the category of F2A, so spouse or child under 21 of a lawful permanent resident, then the category shows, instead of a date, it shows a C. And that means current. That means anyone who files, there's a visa that's available. So a spot is available, which means there is no additional waiting time. They can start the process. You can move forward and the government will process the visa and or adjustment of status without an additional waiting time. Now, throughout time, let's say in the last 10 years, there have definitely been times where this category of F2A has had like a 1.5 or 2-year wait. So it really depends and it changes from month to month. And we try to predict what's going to happen. And, usually towards the end of the fiscal year for immigration, which is like September is the last month of the fiscal year, there may be some, temporary kind of changes for the month, but either way, you are subject to the system. So this kind of determines the steps you have to take and when your stepchild can actually get a green card. So, and here's we'll have the link for the visa bulletin in the notes. So if you go, you can always click on the current month. And if it's been past the half, then you'll be able to see the next month's upcoming visa bulletin. Whenever the visa bulletin shows your priority date to be current, then you can file for adjustment of status if the child is inside the country at the same time, concurrently along with the petition. And if not, if the visa bulletin shows your priority date to not be current and there's some waiting time, then obviously you will have already filed the I-130 petition, but you have to wait until your priority date is current, and that's when you can file for adjustment of status, the I-45 and the actual request for permanent residence and a green card. If the child is outside of the country, then again, you will have already filed the I-130 petition. And once it's approved, you'll be waiting until the priority date becomes current. And so once the petition is approved and the priority date is current, those two things are met, that's when your visa processing, will commence. Now, there's some, the timing of it, I won't get into the details of it. There's a filing date chart as well as a final action date. And so there's some subtleties to the visa bulletin and when National Visa Center will start, open the case, in preparation for the date becoming current. But either way, the big thing to keep in mind is that you cannot file until, you can file the petition, but you cannot process, your stepchildren cannot process for permanent residence or an immigrant visa until that date is current. And as I mentioned before, the application to get, permanent residence is always individual. So that would be per child, per your spouse and any stepchildren, it would always be individual. Now, unlike the immediate relative relationship, which is U.S. citizen to the child, to stepchild, and to your spouse, for example, here, because you're in this preference category system and you're petitioning for your spouse, as a permanent resident of the United States, you're filing the petition, there actually is the ability to have derivative beneficiaries, which means if your spouse has 3 kids and they're your stepchildren, then you could actually file one I-130 petition and pay the fee of $535 currently, just once, and get everybody in on that petition. But you really want to be careful and consider whether that is truly the best option. And I'll give you an example, which I think kind of illustrates the point of the different considerations you might have, is that let's say you're a permanent resident and you may be either in process for or very soon will be eligible to apply for naturalization to become a United States citizen. Well, what happens is, if you successfully go through the process, let's say you've already filed the I-130 petition, one petition for your spouse and let's say 3 stepkids. And while this is going on, you successfully become a United States citizen. Congratulations, it's very exciting. At that point, the pending petition automatically, or the petition, whether it's approved or whatever, automatically converts the spousal petition to from an F2A category, which is a petition filed by a green card holder for their spouse, to an immediate relative, because now you're a U.S. citizen. So it just automatically becomes a immediate relative petition for your spouse. But then guess what happens? There are no derivative beneficiaries for immediate relatives. So while your spouse, their thing will continue, and if there's any waiting period, that'll be, you'll just move right on forward because you're an immediate relative and no longer subject to the preference categories and other waiting times of that sort. But the children will suddenly be petitionless. And so at this point, you would need to file separate and new I-130 petitions as an immediate relative parent to a child for each of the 3 stepkids. And they obviously will be further back in time, and they will not be able to either, process for the immigrant visa or adjust status at the same time as your spouse. So, and some clients have said in the past, I'll just make sure I don't engage in the, naturalization process and I'll just wait on citizenship. And sure, that is one option to consider. But it's also happened with this visa bulletin that gets published every month that right now there's no waiting time. So you're thinking in your head, okay, it'll take like a year and a half or something, and my spouse and my new, and my stepkids, my family will be able to join me, let's say in, a year and a half or whatever time that you predict from now based on the current visa bulletin. Well, if that visa bulletin and your category retrogresses, which has happened many times throughout, let's say, the past decade or so, and suddenly that waiting becomes 2 years, like I mentioned before, then your plans are out the door. And at that point, you will have lost the ability to, maybe then move forward with citizenship and to get the process moving. So for all these considerations, I don't readily recommend that people just file one petition, although we have done that, one petition for your spouse with the stepkids as derivative beneficiaries. But we have done it, but it's something you want to really think about and consider the different aspects before doing that. One more thing I want to add is this has less to do with filing a petition, and it's more at the, immigrant visa processing stage, but this is something you really want to think ahead and be prepared for, which is that when you are petitioning for stepkids to become permanent residents of the United States, especially at the consulate, you need to have permission, where it's relevant or applicable, of not your spouse, but the other parent of the children. So, because if you know that the other parent will object to the kids leaving the country and becoming permanent residents and living in the United States, that's something you need to figure out. You don't want to be a year down the line into the process only to realize they won't be approved because the consulate won't have, won't be satisfied that this is agreed to. Now, obviously, this wouldn't apply if your spouse is the only one with complete, legal custody of, over the children. But again, this is an issue that you want to think ahead for. We also will include, as you can see here, a link for USCIS's page on permanent residency for children, sons, and daughters. And so that's a resource page that you can also look and get an understanding of what USCIS, the agency that will be adjudicating the petition at least, has to say about, some of the requirements for this. So I know it went into a little bit probably more depth than I had intended, but I hope you have a better understanding of what's involved and some of the issues that come up in petitioning for stepchildren and kind of the legal framework that impacts and governs that process. So, because the goal is to be together with the family that you love, in the place that you want to be. So I wish you the best of luck on that. And please feel free to contact us if you have any questions. And I hope you have a great day. Thanks. If you like this content, check out these videos for more information regarding immigration. Don't forget to hit the subscribe button if you want to be notified when we post weekly. You can also follow us on social media where we give more information on immigration and business law.